Hello everyone, this is Sanya, a student of second year of Campus Law Center doing internship at ubAdvocate under the tutelage of Jeevan Prakash Sir, Advocate on Record, Supreme Court. So, my today's topic of discussion is Consumer Protection Act. So, coming on to Consumer Protection Act, what are its definitions, its features, and further procedure coming out. Thus, Consumer Protection Act 1986 was enacted for better protection of the interest of the consumers. Thus, this act came into force with effect from 15/4/1987. Further, this act imposes a strict liability on the manufacturer in case of supply of defective goods by him and a service provider in case of deficiency in rendering of its services. Coming on to the features of Consumer Protection Act. Thus, Consumer Protection Act helps in providing better protection, further helps in establishment of consumer councils, promotion of rights, thus helps in speedy redressal mechanism, provides effective safeguards and act as a Magna Carta for Indian consumers. Why there is a need of consumer awareness? Coming on to this topic, that why there is a need of consumer awareness. There is lots and lots of exploitation of consumers being done in and around. Along with it, poverty and illiteracy of the consumers are on high peak. Ineffective consumer laws, information gap, lack of awareness, lack of education. These are the factors, along with the absence of quality consciousness, misleading done by the sellers. All these factors playing a major role that why there is a need for consumer awareness. Further, coming on to the rights of consumers, that what are the rights which are available to a particular consumer. Right to safety, right to information, right to choose the product of their own choice, right to be heard, right to seek redressal as a compensation from the court, right to consumer education, to get the education, right to basic needs, right to healthy environment. So coming further, here we come across difference between what is the difference between the earlier law, that is the Consumer Protection Act 1986, and the recent bill which has been passed in the Rajya Sabha, Consumer Protection Bill 2019. So where we doing a comparison of Consumer Protection Act 1986 followed by the Consumer Protection Bill 2019. If it comes on to filing of the complaint, a complainant needs to be filed in the consumer court under whom jurisdiction of the seller falls under. Whereas in Consumer Protection Bill 2019, a complaint can be filed from anywhere or from where the consumer resides. Coming on to the next point, the jurisdiction one, the main important point, that the jurisdiction at district level was complaints worth rupees 20 lakh in Consumer Protection Act 1986. Whereas if coming on to the Consumer Protection Bill 2019, district level authorities can take up complaints with the goods and services worth up to 1 crore. Further, there is no provision of e-commerce under Consumer Protection Act 1986, whereas e-commerce transaction will come under the provisions involving direct sales in Consumer Protection Bill 2019. If I have to talk about video conferencing, the provision is not being mentioned in Consumer Protection Act 1986, whereas if I'll talk about Consumer Protection Bill 2019, consumer can seek hearing through video conference. So, this is the major difference between Consumer Protection Act 1986 and Consumer Protection Bill 2019. There is a helpline number by which a consumer can seek the redressal by dialing on to this number, that is 1800111400. A Jago Grahak, this is a site where a consumer can redress their complaint and further can seek the redressal from the particular forum. So now coming on to the leading cases. First case, we will be discussing about the Nippon Nagar versus Embosses Institute of International Business, a 2007 Supreme Court leading judgment. In this case, the student had left the institution within the short period and the vacancy caused had been filled up, and therefore there had been no loss of any kind to the respondent institution. Considering this fact as well as giving effect to the guidelines given by the University Grants Commission. It was held by the National Consumer Forum that if refund is not ordered, it will be unfair and unjust on the part of the institution, thereby bringing such kind of cases within the ambit of Consumer Protection Act. Coming on to the next leading case, that is Subhash Yadav versus Force Limited and others, a 2012 Supreme Court case, wherein the Competition Commission of India (CCI) opined the purpose of Competition Act is to protect and promote fair competition in the market. However, for the protection of individuals' consumer interest, which is the main objective of Consumer Protection Act, another statute already in existence, known as Consumer Protection Act 1986, which mainly deals with the protection of consumers' interest against the deficiency in the services of goods being purchased by the consumer from the sellers. Coming on to the leading next case, that is Pratibha Pratishthan and others versus Manager Canara Bank and others, a 2017 case, wherein the issue taken up by the court was whether a complaint can be filed by a trust under the provision of Consumer Protection Act. That a reading of the definition of the word complaint, complainant and consumer makes it clear that a trust cannot invoke the provisions of the act in respect of any allegations on the basis of which a complaint could be made. To put this beyond any doubt, the word person has also been defined under the act, and section 2M therefore defines a person as follows, which include whether a firm is registered or not, a Hindu undivided family, a corporate society, and every other associated person under the Societies Registration Act. Thus, it was held in this case that the Supreme Court, while arriving at the conclusion, made the references to the definition of the complainant and complainant and consumers under the Consumer Protection Act, and held that it is quite clear from the definition of the complainant that it does not include a trust. Further, coming on to the last judgment of the recent year, that is of 2021 Supreme Court, Diamond Exports and another versus United India Insurance Company Limited. In this case, the Constitutional Bench has thus noted that it is true that justice hurried is justice buried, a main leading quote, but in the same breath it is also said that justice delayed is justice denied. So therefore, the legislature has chosen the latter, and that's true for a good reason. It goes with the objective sought to be achieved by the Consumer Protection Act, which is to provide speedy justice to the consumer. It is not that sufficient time to file a response to the complaint which has been denied to the opposite party. It is just the discretion of the extension of time, which is beyond 15 days, has been curtailed, and consequences for the same have been provided under section 13 subclause 2 subclause B subclause section 2 of the Consumer Protection Act. It may be that in some cases the opposite party could face hardship because of such provisions, yet of achieving the objective of the act, which is speedy and simple redressal of consumer disputes, hardship which may be caused by a party which has to be ignored. Thus, was owing to social welfare intention of the Consumer Protection Legislature, which essentially seeking to protecting the interest of the consumers. Thus, by this, thank you so much, sir, for giving this opportunity to be a part of Intern at ubAdvocate. Thank you so much.